Dr. Kwabena Donkor, a former energy minister. Na yenene bekambrofo. Doc, welcome to Angel 102.9 FM and Angel TV.
Thank you.
A very quick one. We woke up to the news of a judgment debt that has been brought before Ghana. That is about $140 million, which has resorted to the selling of properties of Ghana in UK. Now, there has been a linkage of that story to your former office. Briefly, what is the linkage there?
Excuse me, let me correct this impression. There has not been a sale of any property yet.
Right.
A property has been attached. That is different from a sale. A property has been attached.
Okay.
Yes.
Now, diving into the substantive matter, what is the linkage between this judgment debt that we are talking about as a Ghanaian people and that of your former office?
I think on the subject of the judgment debt, the best people to speak on that will be the Minister of Finance and the Attorney General. They handle that, so they will be the best people to speak on that. I can only speak of the termination of the Ghana Power Generation Company's contract, and the contract which was negotiated by a team led by myself as the then Minister for Power. That I can speak on. But in terms of the judgment that is not within my remit.
That's okay, sir. So we want to understand what entailed in the contract between the government of Ghana, which you said you led it, and that of Trafigura. What did it entail, please?
Okay, let me again be very specific. The contract was not between government of Ghana and Trafigura. The contract was between the government of Ghana, represented by the then Ministry of Power, and Ghana Power Generating Company, a subsidiary of Trafigura. So that I just want to be technically accurate. This was one of the emergency power agreements we signed. It was brought to Parliament and approved in July 2015. It was for a 4-year duration. That is, the tenure was 4 years. And they were to bring on board 107 megawatts of power. The unique thing about this particular agreement was that of all the emergency power agreements we brought on board to resolve the issues of load shedding, this was the cheapest in terms of tariff. The capital recovery cost was 4 cents per kilowatt hour. Again, it had the shortest tenure of 4 years. Again, this was the only contract that did not require a Ghana government guarantee or a pool call option. So in terms of the terms, this was probably the best we could negotiate at that time under emergency. I just thought that should be clear.
So what could have led to the abrogation of that contract, to the best of your knowledge?
Well, the letter I cited and which I raised issues with in the 7th Parliament, signed by Honorable Bwachajakun, purportedly terminating the contract, indicated that, among other things, the company had not received all the necessary permits to start construction, including energy commission permit. At that time, I held a press conference and said we were terminating the contract on very, very weak grounds. Because in the main contract, one of the obligations of the government of Ghana was to assist the company obtain all the necessary permits. And it's not just with this company, all the power agreements. There's an obligation on the government of Ghana as a party to the contract to assist the entity in obtaining all the necessary permits. And therefore, it goes ipso facto that if there was that obligation, we then cannot turn around and use the existence of the permits as a condition to terminate, and that was one of the reasons, one of the issues I raised. And the second issue was that inherent in that contract, inbuilt into that contract, like all other contracts in the power sector, there is a termination process. There's a termination clause. So the contract will always envisage a possibility of termination. And so there is a process you follow to terminate the contract. That was not also followed.
But was the acquisition of these permits part of the explicit terms of the contract? That is to say, were they part of the integral terms of the contract for which when it is in breach, you can terminate it? Was it part of it?
Well, yes. In every country or in our jurisdiction, you cannot just go construct without a work permit, without Energy Commission permit as a regulator, and among others, an environmental protection agent permit. For any construction project, you need those permits. Those are conditions precedent. However, there was an obligation on the part of government of Ghana to assist them to obtain those permits. And the government of Ghana was also obliged to assist them to procure a site for the plant.
So in this case, these were condition precedent. If from the layman's point of view, these were conditions that ought to have been met before the contract was signed.
No.
Go ahead. We listen to you.
No, before the power plant starts operating, not before the contract was signed, because these are terms contained in the signed contract. That these are the things you need to do before the power plant can start operating. That is the difference.
What was it agreeable between the two parties, the forum that in the event where this matter does not go in the way that the contractual agreement agrees on, you will resolve the matter? Was it agreed in the contract?
Yes. So in all such contracts, there's always an arbitration clause. When there's a dispute, the dispute will have to be settled by arbitration. And let me make this clear. This arbitration took place in 2021, and the government of Ghana was found to be at fault. And so an award was made. Then the government of Ghana agreed and negotiated to pay by installment. And that also we defaulted. And that was what led to the other party going to court in UK, because the arbitration was an international arbitration terms in London. The panel was in London.
On hindsight, what do you think we could have done different to be able to avert this payment of judgment debt?
I personally think we were power consumed. We thought we had all the political power, and so we could do anything. And so we paid scant regard to terms of contracts. And this is not the only one. Let's be very clear that in an international contract, there's always a process. And we should be extremely careful as a nation to respect processes and contracts. That we have not done. Because internally, we've gotten away with murder. We terminate contracts, do things because we have the power. But when it comes to international contracts, they will always respect the process. Unfortunately, the reasons we advanced for termination were seen not to be sufficiently good reasons. And indeed, let's remember that in 2017, some of us raised the issues when we saw where we were going. Look, assuming that admitting that we didn't need that extra plant at that time, we could have asked them to delay the implementation. We did that to the Jacobson plant. We did that to the Amandi plant. You stagger when they should come online. So we could have asked them to do that.
I was about asking you the benefit of that agreement we had, because for some time now it has been abrogated, but it looks like we still have a stable power. And for that matter, what was the need? What warranted the agency in which we had that agreement with the other party?
Remember, this was in 2015. Remember, this was an emergency power plant that was meant to have augmented our power supply for 4 years. Remember, there was also the AXA emergency plan. The term, the duration has lapsed, and the government of Ghana, under the present government, has gone further to renew that agreement for a further 10 years. Meaning that there is the need, as we speak, our power supply and demand situation are almost at equilibrium. And in the next 2-3 years, we will need some additional power. And to be fair, the Minister for Energy has categorically stated that we need additional generation. To be fair.
Did we in any way benefit from that agreement before the abrogation?
How do you benefit when it has not come into production? When you terminate the contract, even before it generates, how do you benefit? Remember, one of the major policy objectives of the ministry then was for Ghana to be a major power exporter. Remember that. Currently, we are unable to meet the demand for power from Burkina, Mali, etc. We are supplying them less than what they need, ideally. Let's also put that in mind. So the power sector, especially through the West Africa Power Pool arrangement, has the possibility of being a major export earner for Ghana. We've been exporting power to Togo and Benin. Now with other Burkina Faso, we could do Mali, and we could do more there. So let's keep that in perspective.
Thank you very much for your time, sir.
Thank you.